Good evening, ladies and gentlemen. Smithtown Planning Board is now in session. Would you please rise and join us in the
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We thank you. Please.
Good evening, Mr. Chairman and members of the board. The first item on the agenda, the Planning Department recommends the following items for adjournment as we have insufficient information to act upon them. Part 2, Item 2, number 2011-04, Indian Head Family. Item 6, number 2010-06, KVC Holdings. Part 3, Item 8, number 1053A, Berg Estates. Item 9, number 911A, Glen Hill Northern. Part 4, Item 10, number TC11-01, T-Mobile Northeast. Part 5, Item 11, the 280A application of Olivia Estates. Mr. Chairman, these are the items the Planning Department recommends for adjournment this evening.
Is there anybody here that wants to be heard on those items to be adjourned? A motion?
I'll make a note.
Chairman, I'd like to make a motion to adjourn the items read.
Second.
All those in favor?
Aye.
Opposed? So ordered.
Mr. Chairman, the next item on the agenda under Part 1, Item 1, number 1137, Stanton Platt. The applicant is requesting to subdivide a .9255-acre parcel into 2 single-family lots. This application was previously presented to the board at the May 20th, 2009 Planning Board meeting, at which time the board denied the applicant's proposal. A letter of the denial is attached to your memorandum. The applicant subsequently brought action against the planning board challenging the denial. The applicant was awarded a favorable judgment from the court, and the review process of the proposal recommenced in June 2010. The map was distributed to all town departments involved in the review process on June 2nd, 2010. The planning department received comments from the engineering department on June 8th, asking for revisions to the map. Comments from the highway department were received June 10th, asking for revisions. The Traffic Safety Department had no objections to the proposal. The applicant submitted revised maps per the Engineering and Highway Department's requests on January 14, 2011, and a revised tree preservation and land clearing plan on January 18, 2011, per DEW's comments dated August 16, 2010. The final map of Stanton Platt, number 1137, is comprised of a single tax lot that is rectangular in shape. There is an existing 1.5-story dwelling on lot number 1, and 1 new dwelling is proposed on lot number 2. Lot number 1 has road frontage on an existing town road known as O'Shea Lane, and lot 2 has road frontage on an existing town road known as James Place. To the north and west of the site, zoning is R10, single-family residential 10,000 square feet, and properties to the south and east are zoned R21, single-family residential 21,780 square feet. The proposed lots meet the lot area and setback requirements for the R10 zoning district, and no variances are required. The property is mostly level with elevations ranging from 124 feet to 128 feet above sea level. The depth of groundwater is more than 10 feet, and no problems are anticipated with respect to groundwater. The site does not contain any wetland or natural surface water features. The proposal appears to comply with the standards of the Suffolk County Sanitary Code with respect to sewage flow and septic system setbacks. The Engineering, Highway, and Traffic Safety Departments recommend approval. The following resolution is recommended for Stanton Platt, number 1137, from the Department of Environment and Waterways, pursuant to the State Environmental Quality Review Act. Be it resolved that the Planning Board of the Town of Smithtown hereby declares itself lead agency on this matter, and finds that this matter is subject to the State Environmental Quality Review Act and is classified as an unlisted action pursuant to SECRA. And be it resolved that the Planning Board of the Town of Smithtown does hereby issue a secret negative declaration. Determination of non-significance and environmental impact statement is not necessary in the matter of the application for subdivision approval by Donald and Virginia Stanton for Stanton Plat number 1137 for the following reasons. A, the proposal does not appear to significantly threaten any unique or highly valuable environmental or cultural resources as identified in or regulated by the Environmental Conservation Law of the State of New York or the Smithtown Town Code. B, the parcel does not appear to suffer from any severe environmental development constraints, no poor soil properties, no high groundwater, and no unmanageable slopes. C, the small size and nature of the proposal mitigate against a significant adverse impact upon the environment. D, the small size and nature of the proposal mitigate against a significant adverse impact upon the environment, E, the proposal appears to be consistent with the planned use of the parcel and compatible with neighboring land use. F, the project as proposed on the tree preservation and land clearing plan prepared by Robert J. Mavrikakis, licensed land surveyor and dated March 8, 2011, provides for the retention of existing trees and natural vegetation upon development of the subject parcel. The Planning Department offers the following resolution for the Board's consideration. Be it resolved that the final plat of Stanton Plat, number 1137, is hereby approved, subject to the following conditions. Mr. Chairman, conditions A through L are standard conditions that are placed on all subdivision applications. And be it further resolved that the Chairman of the Planning Board is hereby authorized to sign the final plat, thereby approving said plat after the Town Board has posted a performance bond of satisfactory form and amount. And be it further resolved that the conditional approval of said final plat shall expire 180 days after the date of this resolution, and within 90 days after the Chairman of the Planning Board signs the final maps of this plat, unless said plat shall have been duly filed or recorded by the owner in the office of the Suffolk County Clerk. Mr. Chairman, this is the recommendation for Stanton Plat, number 1137.
Anyone here representing the applicant?
Good evening, Mr. Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. We have reviewed the recommendations of the Planning Department. I have, excuse me, Mr. Mavrikakis is here, Andrew Stanton, Mr. Stanton's son, and also their, I guess you'd say, their regular counsel, Carol Pluta. We've all reviewed the document, and we find it acceptable, and we thank the board for hopefully approving this application.
Thank you. Is there anyone here that wants to speak on this application? Give your name and address, please.
Michael Ryan, 27 Arlington Avenue. This property adjoins my property, and this is the first I'm hearing of this.
Well, it's been posted 2 or 3 times, I think.
Where?
Well, it's been, I know at least twice it's been posted. And that's on O'Shea and on James Place it was posted.
Right, but not on Arlington, right? They
Well-
said this property adjoins my property.
No, but you should have received a letter.
I have not received the letter.
Didn't
What's
receive
that?
a letter. No.
I'm sorry, what's that?
For subdivision approval, there is no letter that is sent, only for zone changes.
Can I ask, I'm sorry. Can I ask why it was denied the first time?
Yes, you can say something, absolutely.
Why was it denied the first time?
You what?
Why was it denied the first time?
Well, I have no idea there because they've certainly been on at least 2 or 3 times.
Maybe the planning director can refresh our memories as to
Okay.
the basis of our denial.
There was a question as to regard whether the survey lines were correct on this particular parcel
Okay.
and accurate.
Then the applicant went to court after we denied him and beat us in court. So here we are.
Okay. And what is the minimum plot size for this?
What is the what?
Minimum plot size requirement?
Well, it's, I think it's over an acre of
Well-
land that it represents. This case also went to court
I understand.
because of that discussion there about the size of the property and so forth.
Is the size
And
of
the
the,
judge has adjudicated that it had to proceed.
is the size .9 something? of
That's
the-
correct.
Of the entire plot,
I
right?
can
Yes,
give you an
0.9 acres.
So the subdivision plot becomes what size?
They're each approximately 20,000 square feet.
And that meets the requirement?
Yes.
Okay. All right.
.9255 according there to the,
In total, right?
yes, almost an acre.
Right. So the requirement, what's the minimum requirement? 20,000 square feet?
Well, there's two requirements. The first requirement is the zoning requirement, which is quarter acre. That's a quarter acre zone, meaning the minimum lot size has to be 10,000 square feet. However, what supersedes the town's requirement is the Suffolk County Health Department requirement for septic systems, that in this area, it is required that the minimum lot size be 20,000 square feet. So the lots meet the higher standard.
Okay. And one last question. How can I see a copy of the drawings?
We'll show it to you right now.
Okay. Thank you very much.
Okay. Is there anybody else here to speak on this? The gentleman in the back? Give your name and address, please.
Good evening. My name's Charles Palmer. I'm on 16 James Place. I just wanted to know, is it going to be a cut-through street? Is it going to connect the streets? I only lived there about a year and a half, so I'm not sure even what's on the other side, but is it going to be like a cul-de-sac, or is it going to connect the streets?
Streets are
It's going
remaining
to be
as
a
is.
driveway coming into the,
I'm sorry, the streets are remaining as is. You could take a look at the map. That's right here, but there's going to be no, outside of alteration with some of the end of the streets for a turnaround and a driveway, there's no real change.
Right, so it's basically like a cul-de-sac.
That's correct.
Okay, okay. That was my question. Can I take a look also?
It's public information, yes.
the other gentleman in the back? Your name and address, please.
Good evening. My name is Andrew Stanton. I live on 10 David Lane in St. James. I just wanted to state that I personally visited Mr. Ryan at his home and gave him a complete set of copies of the plans probably over a year ago of exactly what was going on and explained the entire situation. So I just wanted to make sure that that was known, that he was fully aware and did have a complete package with every drawing and everything that was going on, including all of the notes and everything on this particular case.
Okay, thank you. Is there anybody else on this application?
So as far as I understand it, we have a court order requiring us to approve the subdivision, correct?
I don't believe the court order requires you to approve it. What the court order says is the reason for denial was not upheld. If the board would have to find some other reason to deny it, which I am, that was the only question that we had raised. Outside of that, I would.
that it was denied for the last time regarding the questions with the boundary lines and
That's
things of that
correct.
type.
That's all been settled by the court.
Yes.
Okay.
Yes, sir. Are you about finished there with your review?
Yes, sir.
Okay.
Thank you.
All right. Let me have a motion on the sequel negative, please.
Mr. Chairman, I'd like to make a motion in regards to Stanton Plat number 1137 to approve the motion regarding sequel negative deck.
Second?
Second.
All those in favor?
Aye.
Aye. Motion on the final plat for Stanton, 1137.
Mr. Chairman, in regards to Stanton Plat number 1137, I'd like to make a motion to approve, subject to the conditions read.
Second.
All those in favor?
Aye.
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 Also,
Opposed, so ordered.
subject to the conditions that were in the memorandum that were
Correct.
not read as well.
That's right.
The conditions that were in the memorandum are before us.
The performance bond, please.
Be it resolved that the chairman of the planning board be authorized to sign the performance bond estimate for the map of Stanton Plat number 1137 in the amount of $6,700 and establishing an inspection fee of $536 and a cash deposit of $500. Therefore, the amount of the performance bond to be posted with the town shall be $6,200.
A motion?
Mr. Chairman, in regards to stamp plat number 1137, I'd like to make a motion to approve the resolution authorizing the signing of the performance bond estimates.
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered. We thank you.
Mr. Chairman, the next item on the agenda under Part 2, Item 3, number 2010-02, King Cullen Grocery. Mr. Chairman, this item was brought before the board for a public hearing at the previous planning board meeting on April 20th. It is now coming back this evening with an evaluation for the board from the planning department as well as a recommendation. I'm going to read the evaluation to you now. The advantages of this proposal. The proposal will allow, an extension of the existing supermarket, providing improved service to the residents who use the market. Approval will encourage improvement of buffers with the adjacent residential neighbors. The disadvantages: approval may bring some activities associated with the supermarket operation closer to the adjacent residences. Approval in accordance with the proposed site plan will require a parking variance from the Board of Zoning Appeals. The Planning Department recommends approval of this petition and offers the following resolution for the board's consideration. The Planning Board recommends that the Town Board approve petition number 2010-02 of King Cullen Grocery, 185 Central Avenue, Bethpage, New York, for a change of zone for property identified as Suffolk County Tax Map number 56-1-3 from R10 residential 10,000 square feet single family to Central Business District, subject to the following conditions. 1, approval of this petition does not imply approval of any current or proposed uses or site plan on this site. Such approval shall be determined by the Board of Site Plan Review. 2, the site shall be developed in substantial compliance with the plot plan dated February 8, 2011, excluding any changes required by the Board of Site Plan Review. 3, approval of this petition does not imply approval of any specific parking lot layout, such layout to be determined by the Board of Site Plan Review. 4, there shall be a buffer planted along the southern boundary of the subject site as determined by the Board of Site Plan Review, sufficient to provide an adequate buffer for the residential property along 3rd Street. 5, the petitioner shall upgrade the septic tank in the leased area of the supermarket parking lot in compliance with the requirements of the Suffolk County Health Department. Mr. Chairman, this is the Planning Department's recommendation for King Cullen Grocery, number 2010-02.
Is there anyone here representing the applicant? Nobody here?
Yes.
We better adjourn it then. What? Well, the only thing he's got is a recommendation. The recommendation, yeah.
It didn't say that?
Well, if there's a need for council to be here, we better, adjourn it?
He knows.
Council?
Is he required to be here? He's not required. He can proceed in his absence.
We always call them and send them the copies of the recommendation.
Okay. I'm talking about the matter was going to be on tonight. How do you notify them?
Well, he has other things on the application tonight, doesn't he, the council?
No, he does not.
No, he doesn't. Was he notified on this?
Yes, he was.
By phone?
Well, in this particular case, we explained to him at the last meeting, and he was probably called by, I'll have to check with Agnes, but we always call the attorney to let him know when the decision is going to be raised. And I believe he does have a copy of these conditions.
I just have a question before we go further, one way or the other. On item number 6, is that a typo? It says May 2011 update?
Yes, it is. Should be April 20th.
April.
April 20th,
April
2011.
20th.
Right.
but it does refer to something that occurred following the May 5th, 2010 meeting. Is that correct?
I think it's referring to something that was to happen either at or after the May 5th meeting,
May 5th, 2010 meeting? Now today's,
not today's.
No, no,
or actually
2010.
tomorrow, right. So it's supposed to be a reference to an April 20th, 2011 update referencing something that was supposed to possibly happen after the May 5th, 2010 meeting.
Correct.
Well, I definitely want to add one thing there to the paragraph 8 and on the 4, that the buffer along the southern boundary should also be on the western boundary of that property. That's the part that's on Washington Avenue.
Number 4.
Wait a minute. No, we are saying that this
You had the buffer on the southern side, but you didn't mention there the western
Westerly.
side, which borders there on Washington Avenue,
Okay.
okay?
We'll add,
And southern
well, the
boundary.
southern and,
Southern
Westerly.
and western.
and western boundary.
Yes. Well, I think then probably better adjourn this then, if we don't have counsel here, and we should have counsel.
Frank,
There's no comments from anybody tonight
Mr. Chairman, I don't,
from the standpoint there of hearing this. If this was not, if the council was here, we would vote on it. But we've already had all of the comments about the money and, what?
I respectfully object to adjournment because we're all...
This is the residential lot.
Mr. Chairman, just 1 second. Mr. DeRubius, how was the applicant's counsel made aware of these conditions that you've articulated?
Well, generally, he would discuss these with Elaine Learned on the staff, who is my principal planner who handles these things.
And can you say for a fact that that occurred in this case?
I would say probably 90% certainty, but I don't have the information. Elaine's been out sick for a week and a half.
Mr. Shul?
There's no need for the attorney to be here for us to act.
What
And,
about the fact that we're not certain 100% that he's aware of these conditions?
Well, it could permit him an opportunity to say that he wasn't notified and whatever, but we have the recommendation of the planning board to the planning department to the board. There's no requirement that the attorney be present. That doesn't preclude him from raising the issue later on, should he claim his rights were prejudiced in some way.
what's that, Mr. Shul?
That doesn't preclude him raising the claim that his client's rights were prejudiced, but I think these matters were all discussed at our April 20th meeting.
Well, Mr. DeRubius, I just have a question, and maybe Mr. Shul could chime in. There's no resolution. Wouldn't there normally be a resolution for us to vote on?
Well, that is the resolution. It should have had be it resolved on it, but it did not. The person who normally writes these...
There would be a resolution that we would move to adopt a resolution in accordance.
Well, actually,
as
that
read,
is
or-
the resolution that you have attached to that, except that it's missing the phrase, "be it resolved."
I mean, the part that says recommendation is supposed to be the resolution,
That's correct.
but it's supposed to say somewhere else, normally there's a resolution, right?
No, if you look at this, what normally is the first sentence is, the planning department recommends approval of this petition and offers the following
Right.
resolution for the
Right,
board's
right.
consideration. It should have begun, be it resolved that the planning board recommends to the town board, and we did not put that phrase in.
So it's just like an oversight?
Yes.
Oh, now, also, the conditions, you say these are conditions that we were discussing. You think you're 90% sure that the attorney to the applicant, who is apparently afforded an opportunity to be here tonight but is not here, is aware of these conditions. However, the chairman has just requested that one of these conditions be added to or amended. And, Mr. Shul, does that pose any problem for us, the fact that we're amending the condition now, unless Mr. DeRubius, a staff member, knew that we were going to make that amendment when she spoke to him,
If I
he
could,
would not have known.
if I could add, Mr. Pizzulli is well aware, at least verbally, of all of these conditions in terms of this. We discussed what we were going to say at length.
Right, but the chairman just requested an adding in of a
I
condition, which is not in the
include-
memo.
Okay, what I discussed with Mr. Pizzulli was that he was going to have to put something on Washington with regard to this. In other words, some planting or whatever.
Did he agree to do that?
Yes, he did.
So that the condition that the chairman wants amended, that amendment was discussed with Mr. Pizzulli, and he's, as far as you're concerned, he's willing to go along with it.
Yes, I verbally discussed that with virtually all the items that you have intact here I said that we were going to have the Board of Site Plan Review make the determination with regard to the parking that was going to be here and make all the other determinations that you have here, as well as what the buffers were going to be that surround the particular property. I also informed Mr. Pizzulli that I would make a recommendation, since they're reconstructing the parking lot, that he has to replace the septic system on the property involved, the VFW property, and Mr. Pizzulli had agreed to that. In fact, I believe he even stated that at the last meeting.
Mr. Chairman, based on planning's representations, I'm comfortable, and council's comments, I'm comfortable moving forward personally.
A motion then to approve the change to the zoning there to the town board for the King Cullen application
Before you get to that, I believe
as amended.
there's a question.
Yes.
I have a question. What has been done in regarding our request that they not build to the property line, a buffer, if you will? Oh, sorry.
My name is Frank Tadero, commander of the VFW at 460 Lake Avenue. We had raised some questions about their building was going to come directly to the property line, and we had requested that they have a setback or a buffer zone. Has that been included in your proposal?
Well, it certainly there is in the record.
Okay, if I could mention,
Then they amended?
no,
Oh.
the zoning requirement permits in this particular zoning category, which is essential business, to build right up to the property line. So the applicant can do that. He met the zoning requirement, so therefore, unless this board wants it set back, that's what the zoning requirement he's entitled to. The issue, however, with regard to the VFW that you explained at the last meeting, which was that they did not have a right to go over your property to access the parking on another property that they own. That's been referred to the town attorney, and that will be determined by the town board whether the board can act on this particular site plan or not based upon your objections.
So where do we go from here about keeping them off the property line?
Well, that's a request that you would have to make and see if the town board would honor it, but that's a question of zoning. He's entitled to bring it right up to the property line. As well as you are entitled to on your building, you're entitled to build right up to the property line as well.
Even after there's a building already there?
That's
If we decide
correct.
in the future?
Yes, you're in the central business zone, which that is. The buildings are permitted, like in most downtown areas, to touch each other. So you're allowed to build side by side.
Well, now, at this stage of the whole proceeding, this board is just going to make a recommendation to the town board
Right.
as to whether or not the zone change they seek makes sense from a planning perspective or not. And then ultimately, it's going to be decided by the town board as to whether or not that zone change should be allowed, correct?
That's correct.
So that whatever concerns anybody has concerning the building going right up to the property line, if the matter goes to the town board, then those concerns really can be brought to the town board at that time.
That's
And
correct.
if the town board wants to approve the change of zone with the condition that they can't build up to the property line, they can. Is
Yes.
that correct? So that if this is going to be approved tonight as per the recommendation of the planning department, can we just send also a recommendation that the issue of whether or not they can build up to the property line should be considered? And then it's up to the town board to decide one way or the other, and then anybody who wants to voice their opinion to the town board can do that.
Well, we try to leave some flexibility in it. If you notice the way
That's
we
what I'm
wrote
saying.
the way we wrote the conditions here, we were trying to say that we only want the general configuration that's there, that the details would be up to, the Board of Site Plan Review is the town board. And so what we said was let them make those specific determinations. What we were saying, in what in layman's terms, what we're trying to say in this resolution is that the proposal that they submitted, which was for a 4,000 addition on one side of the building, keeping the house where it's located, keeping the parking about how it's designed, not necessarily all the elements of it, but that is what this board is considering favorable. All the details, what we're saying, and that's why we put all these conditions on here, are going to be left to the board, which is the town board, to make those decisions. That's what we are trying to say. In other words, we're trying to give the board, you're approving this in concept, but leaving the details up to the town board.
So basically, the concern that's been expressed about building up to the property line, if it goes to the town board, that's really something that should be addressed there.
That's correct.
Frank, will the town board
Thank
be
you very
having a
much.
public hearing?
Yes, they will be.
The town board will be having a public hearing on it?
That's correct.
Okay. So any concerns from this point on, if we do approve, could be heard at that public hearing?
That's correct.
Thank you.
All of these questions that you've asked at the previous meeting and this meeting will be in the minutes that are going to be put to the town board, so that any of you that want to attend to that town board session, you'll certainly be welcome there, and you can get your answers at that time if we make a motion there to refer to the town board. Okay? Thank you very much. All right, any other questions by the board? None? A motion to refer the application
Mr.
to
Chairman,
the town board for change of zone on the King Cullen.
Mr. Chairman, in regards to, I'd like to make a motion in regards to King Cullen application 2010-02 to approve as read in the recommendations.
Second.
All those in favor?
Aye.
Opposed? So ordered. We thank you, and
Thank you.
we appreciate your concern. Okay, thank you very much. You're not in our way. You're never in our way. No veteran is ever in our way, okay? Thank you. All right, please.
Mr. Chairman, the next item on the agenda under Part 2, Item 4, number 2010-10, Edward and Patricia Martella. Mr. Chairman, this application was presented to the board at a public hearing on March 2nd of this year. The Planning Department read its memorandum and also gave the board its evaluation regarding the advantages and disadvantages of the application. Counsel for the applicant requested, excuse me, that it be adjourned to a future date so that he can respond to the memorandum and the evaluation. And we've brought it back this evening. Counsel is here and I believe is ready to make his presentation. You want to just read the application? Okay. Vinny, do you want me to read the recommendation of approval before you?
Yeah.
Okay.
Yes, please.
All righty. Mr. Chairman, I'll read the Planning Department's recommendation for the application. The Planning Department recommends approval of this petition and offers the following resolution for the board's consideration. Be it resolved, the Planning Board recommends that the Town Board approve the petition of Edward and Patricia Martella for a change of zone for the property located on the east side of Lake Avenue, 136.43 feet north of Middle Country Road, St. James, Suffolk County Tax Map Number 110-2-7, from wholesale service industry and R21 residential 21,000 square feet to professional business with the following two conditions. One, approval of this petition does not imply approval of any current or proposed uses or site plan on this site. Two, prior to the approval of this petition by the town board, the petitioner must document the sewage flow rate approved for the property by the Suffolk County Department of Health and how the proposed development complies therewith. Mr. Chairman, that is the Planning Department's recommendation for Edward and Patricia Martella, zone change petition number 2010-10.
Mr. Tramarko.
Mr. Chairman, members of the board, my name is Vincent Tramarko. I represent the applicant. I've heard the recommendation of the Planning Department, and we certainly accept that recommendation and hope that the board will favorably recommend to the town board the change of zone from WSI to PB. Thank you.
Is there anyone in the audience that wishes to be heard on this application? Hearing no one, a motion to approve the change of zone for Edward and Patricia Martella.
Mr. Chairman, in the matter of Edward and Patricia Martella, number 2010-10, I move that we adopt the resolution as read and favorably recommend to the town board a zone change from WSI to professional business with the,
Second.
with the conditions read.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered.
Mr. Chairman, the next item on the agenda under Part 2, Item 5, number 2010-09, RNF Management. Mr. Chairman, this application was brought before the board at the March 2nd, 2011 Planning Board meeting. The memorandum from the Planning Department was read into the public record. Counsel for the applicant did request that the matter be adjourned to a future date to come back for a decision. And at this time, I would like to read the recommendations that the Planning Department has prepared for the board. The Planning Department recommends denial of this application and offers the following resolution for the board's consideration. Be it resolved that the Planning Board hereby recommends that the Town Board deny petition number 2010-09 of RNF Management, LLC, for a change of zone from wholesale service industry to neighborhood business for the following reasons. A, the proposed zoning is not consistent with town's comprehensive plan, which encourages concentration of retail businesses at central locations. B, approval would tend to set a precedent by allowing a significant addition of land to the NB zoning category at a location not usually recommended for NB uses and would tend to undermine existing centers such as downtowns and major shopping centers. C, approval would constitute spot zoning in that the zoning is inconsistent with the pattern of zoning in the surrounding area, and there is no apparent public purpose for the requested zoning at this location. If the Planning Board wishes to recommend approval of this petition, the following resolution is offered. Be it resolved that the Planning Board hereby recommends the Town Board approve petition number 2010-09 of RNF Management, LLC, for a change of zone from wholesale service industry to neighborhood business. Mr. Chairman, these are the recommendations offered to the Planning Board by the Planning Department for the change of zone petition number 2010-09 of RNF Management, LLC.
Mr. Tramarko?
Mr. Chairman, I just had a couple quick questions, if you don't mind, Mr. Tramarko, before you make any comments. As a point of reorientation, this site is just west of Old Willard's Path and Jericho Turnpike, that intersection there?
Yes.
Okay. Based on that location, it came out during the testimony and evidence during the public hearing that it was very close in proximity to an identical application. Is that correct? From the CVS application?
What do you mean by identical? I'm not sure what you mean by that.
An identical zone change application from WSI to neighborhood business.
In that regard, yes, there were
Okay.
there were two. Yes.
And the CVS, which was the subject of that identical zone change application, is how far from the subject parcel that we're talking about right now?
About a quarter of a mile.
Quarter of a mile, okay. Based upon that proximity and the identical nature of the zone change application, I requested that the planning department supply us with the transcripts from that prior zone change hearing, and planning was kind enough to do so. We were provided with transcripts from June 3rd, 1998, June 17, 1998, October 7, 1998, as well as the appropriate memos that went along with those meetings, and I'd like to thank planning for that. I also think it should be made part of the record for this matter for the town board's consideration when they consider, if they consider this zone change. And just to review that prior application with respect to CVS, the planning department at that time in 1998 recommended denial to the planning board. Is that correct?
Yes.
Okay. And the planning board at that time agreed and adopted your recommendation. Is that correct?
Yes.
Okay. And then the matter went to the town board, and despite the planning department recommendation as well as the planning board vote, they approved the zone change application at that time. Is that correct?
Yes.
Okay. One of the reasons tonight we're being urged to deny this application is the concern for setting precedent. Hasn't that precedent already been set, Mr. DeRubius, by the town board, that we should approve this?
I think if you take a look at the memos that were given to you on the CVS, there was a different issue that was present there. I think in that those memorandums, you will see that I said that it met the locational criteria for zoning in that particular area. That the reason why the planning department objected to the CVS was that there was a large amount of vacancy across in the shopping center that was directly across the street. And rather than have a freestanding store in that location with a large vacancy, we recommended denial. That was the reason for the denial. But in the memorandum, it does state that it met the locational criteria for neighborhood business, in that it is located at a center, it is located with a traffic light, so that it permits both left and right turns out of that particular area. So I don't believe that it is a precedent. There's a different issue that's involved. It's a different type of location.
But
Well, with respect to the shopping center across the street, I don't know, did you review the prior transcripts from those hearings before tonight?
No, I did not.
Okay. According to my review of those transcripts, you were very concerned about that shopping center across the street from CVS, correct?
That's correct, yes.
Okay. And at that time, there was numbers in terms of the vacancy in that shopping center at approximately 80% vacancy, correct?
That's correct.
And out of your concern for that vacancy rate, you recommended denial of that zone change, correct?
Yes.
Okay. And what's the vacancy rate of that today?
Well, the vacancy rate, it depends upon what you're discussing, because they reconfigured the shopping center and
Pretty
eliminated.
full, right?
Well, I would disagree with that statement.
Really?
What has happened is that the shopping center owner was unable to rent out the space in the normal event and blocked off a large portion of that center. All the frontage is occupied, but not the entire center.
Okay. Well, what's the vacancy rate now?
Well, again, what I'm saying is the vacancy rate, it depends on, if you talk about the amount of square footage, I would have to ask the applicant or the owner of the shopping center how much he is not leasing. But if you're looking at the store frontage,
Right.
the entire store frontages are rented.
Okay.
So the shopping center is fully rented.
Well, I would not use those terms.
It's
I would not
sig-
agree with that statement.
Significantly better than 80% vacancy, correct?
Well, I would disagree with that as well.
Really?
Yes, I
mean,
would.
Everything looks full in there to me.
Well,
Just for the record, we're talking about the Morwood
Okay.
Shopping Center, correct?
yes, we are.
Okay, just so anybody,
There were two tax certiorari's in that particular area. The taxes were lowered on that particular building because it could not get the rents that it needed for that particular area. The tenants that moved into that space apparently, by their tax certiorari records, are paying less in rent for that particular area, we believe our original analysis that we did in 1998 is still valid.
Well, one of the things you said in that meeting, in your recommendation against the zone change, was that a stationary store would not survive if CVS was put in there, correct?
That's correct.
And to my knowledge, there's a stationary store alive and well there today, correct?
I went there. I didn't see a stationery store.
Okay,
I
well, you
visited.
can buy a newspaper, cards, things like that.
Yes, but I didn't see the stationery store that was there. It was closed.
No.
It closed afterwards.
Okay, but there's a stationary store there now.
I visited the shopping center recently. I didn't see the stationery store.
Is there a card store where you can buy newspapers, et cetera?
I don't know the exact mix,
Okay.
but
Well, I'm pretty sure there is one there.
I'm definitely sure there is one.
I'm fairly, there's a,
Unless they closed the last couple of days.
the last time I was in that shopping center, there was a card store where you can buy newspapers, which is what I would refer to as a stationary store. So what I'm getting at is that these concerns that were expressed in the prior zone change hearing don't seem to have been borne out by time. You disagree with that?
yes, I do.
Okay. CVS has been thriving since it's opened there, correct?
Yes,
And it's been paying taxes to the town since that time?
yes,
And if we denied, or the planning board, not we, but the planning board at that time, denied that application at that time, they never would have opened, correct?
would disagree with that.
Okay. You know,
There was space available in the other shopping center for exactly the same size of the CVS
The-
at that time.
the reason
and-
I'm bringing these issues up is because in these times, I think it's really important that we be encouraging businesses to operate here, not to try to scare them off for any reason, to encourage development of the private sector. And I think by recommending against a zone change like this, it's really unnecessarily making it difficult for these businesses to succeed in town. There's precedent right up the road, a quarter of a mile, where the town board has told us that they approve of this type of zone change application. The planning board denied it last time. The town board overruled them. And here we are again with a recommendation against it, and I just don't understand it. No one has objected to this zone change application. No residents. CVS has been serving that neighborhood for a long time, doing a good job, and they're paying taxes to the town. And I just don't understand the constant recommendations against allowing businesses to successfully operate without all this red tape. And that's my comment. I'm in favor of this zone change application. Thank you.
So anybody else in the audience, by the way, that wants to be heard on this application? All right.
But we haven't heard from Mr.
Any
Tramarko
comments
yet.
there from Mr. Tramarko?
Just a couple, Mr. Chairman. I've been doing this for, I hate to say how long, and one of the things that I've noticed is the problem with WSI zoning. WSI zoning is probably the most restrictive zoning that we have in the town of Smithtown. I think it was promulgated in the late 60s, and it just doesn't work. It's not a good zoning. Unless you want body shops, repair garages, which I believe the planning department states in their recommendation, it's primarily a motor vehicle type use. Well, you can't have a motor vehicle use for the length of Jericho Turnpike from 347 all the way down to Comac Road. It just doesn't work. And some of the ridiculous prohibitions in WSI, which affects my client in this application, is WSI doesn't allow barber shops. I don't know why they don't allow barber shops. I mean, if you want to listen and look at the definition, WSI, wholesale service and industry, it's a service. You want to get your hair cut, it should be in the neighborhood. It shouldn't be that you have to go to these major centers like Mayfair or in Smithtown at a local central business place. So the problem we have, and the other part of the biggest offender in WSI is retail uses. They don't allow, it does not allow retail uses. If you'll remember, you recommended approval just a little further east in St. James of a property on the corner of Sunny Road and used to be the old cider property, a furniture store there many years ago. And you recommended approval to the town board. Town board passed a resolution changing the zone from WSI to neighborhood business. The reason why we come in, oh gee, sorry. Well, that's my wife too. Goodbye. If this was in court, they'd take my my phone away. Oh, come on. I can't talk now. Okay, dear. I'm sorry. Where was I?
I hope they got that up there.
You even got those guys laughing.
The and that was in St. James, and I think, you know, the developer did a great job building a beautiful set of stores. What my applicant has here in I guess we could call it the Comac area, is a multitude of different uses. Most of them are restaurants, which ironically, those are allowed in WSI. Fast food restaurants where you have more traffic generated going in and out. There's a bagel store, there's a pizza, Domino's Pizza, I think, and also Long John Silver or some other fish.
Pudgy's Chicken, I think.
Pudgy's Chicken, okay. So there's 3 or 4 fast food places, and the only violations we have there are a convenience store, which is very necessary in this particular area, because you got to go a mile one way or a quarter of a mile the other way, and there happens to be a need for that convenience store, and it's patronized by many people. Actually, there is a motel, and in the back of that motel, the building in the rear is although some people don't like the idea, they do rent to people that are down on their luck and have been put out of their homes, and there are families that live back there, and some of them don't even have cars, so they can walk across the street and go to this convenience store and buy milk and eggs and the like. To say that this doesn't conform to the comprehensive plan, the problem is the town should change the comprehensive plan, and they haven't. Is it spot zoning? Well, as Mr. Oshrin said, you know, well, we spot zoned once before. Why is it different now? It's a necessity. The WSI zoning is not a good zoning, and the only way around it until they change WSI or give it more permitted uses, which has been talked about for probably a couple of years now, is to make an application for neighborhood business. The gas station that's reasonably close to this, that's on not on Willets Path, but on the other cross street, on the other side, has a convenience store. So it's okay for the gas station to have it, and our rules allow in WSI for a gas station to have a convenience store. But God forbid, you go in and you put a retail use in WSI, the town is down on you in 10 minutes.
Well,
And-
that convenience store and the gas station, that's got to be even less than a quarter of a mile from
That's
this side.
correct. Yes, yes, it's right there. So, I mean, the issue about traffic and so forth, the traffic is there. The convenience store is not going to change it, and the barber shop doesn't do 100 haircuts a day. So I don't see that as being any type of issue with respect to traffic. As an aside, we just mentioned before, I think Mr. Frank DeRubia said he doesn't know if that stationery store is operable or is operating. Well, this morning it was operating, and the truth is I went in there and I bought a lottery ticket, and I have it in my pocket, and it's today's lottery date, so it's there. And there were a few people in there besides me, so I'm not imagining
Did
that.
you hear the numbers yet tonight?
What's that?
Did you hear the numbers tonight?
No.
Oh, okay.
And I represent, or did some work and still do work for the Antonaccis, who own the shopping center that Frank was concerned about in the late 1990s. And as far as I know, they're fully rented. They even have one office upstairs that's rented. I don't know about in the rear whether, you know.
Is it fair to say that it's significantly less than 80% vacant?
Oh, yeah, yeah. If it's probably, it's 100%, except for, and I don't know it to be a fact, if the back of some stores that are very long stores, you know, are not rented, that I really don't know.
Can you tell us about, in your view, what the prejudice to your client would be in the event that we denied this application?
Well, first of all, he would have to lose 2 tenants. The one tenant, the convenience store, I believe is not only, you know, certainly a tenant that pays rent to my client, but it's really a need in that community, in that specific neighborhood. There's no place else to go if you're on foot. And the idea of neighborhood business is to take care of the neighborhood. The other use, a barber shop, again, he would lose a tenant. The barber went in there, and who the heck ever thought that a barber shop wouldn't be allowed in WSI? And I don't know how many barbers would check the zoning, you know, prior to going in there. And I think there's a couple of barber shops along here that are in violation, and they really shouldn't be, because it's a business that's a necessity, and it's usually a neighborhood type of business. When you go for a haircut, you usually don't go 5 miles away if you don't have to. You want to go locally. So I'm not so sure that this whole idea of WSI in the present state that we're in, including the fact that has been brought up, we're in sad economic times, and thankfully my client is fully rented there, and he hopes to continue to rent, and the only way he can do it with this whole deal about retail is to make an application for a change of zone. If they were to change WSI and add many more prohibited uses and make them permitted uses, then maybe I wouldn't be here today and my client wouldn't be here. I think it was mentioned that when we went in for a site plan exemption to fix some retaining walls, that's when it was noticed that my client was in violation for not having, for having 2 tenants in there that didn't meet the criteria of WSI. Well, not everybody checks the zoning. Not everybody would even dream that you couldn't have a barber shop or a convenience store in a row of stores which mostly are utilized by fast food restaurants, which is the biggest traffic getter. As far as parking goes, there's a mention about parking. There's no problem with parking. There never has. I pass that place at least twice a day, if not more, and there is never an issue about parking ever. The other thing I'd just like to mention, and then I'll be quiet, is there's a mention here that Suffolk County Planning Department or Planning Commission basically says, or Frank says in this report, well, you know what, they're really not going to talk about their opinions on these things because it's really a matter for local determination. And anyway, we're not going to comment on it, and yet they comment on it, and you got 4 reasons why the Suffolk County Planning Commission says that this application should be denied. Well, if they're not going to comment on it, they should shut up and not comment on it. But yet they do. How that happens, I don't know, and I guess I'll never know. But WSI just doesn't cut it anymore, gentlemen, and we have to look to the future and help people in this community that are entrepreneurs and are taking chances in order to make money, but at the same time give other people the opportunity to make money, these tenants, and also provide a service to the local community. So I ask this board for their favorable consideration, recommend to the town board that this matter be approved. It's really not spot zoning anymore. We don't have any other way to go. Thank you.
Mr. Tramarko, I have a question for you. May I, please? Sure. You had mentioned the similar type of change that was on Sunny Road in St. James.
Yes.
By the way, the landscaping is beautiful, and I think that enhances that whole little area. When we deal with, and if we do go on a positive approval on this particular resolution, is it possible that your client would consider, and possible that the board could incorporate this, that we have some landscaping done on that particular lot that we're considering the zone change on? If you look at it now, it's kind of, I'm going to say, like dismal looking. Is it possible to incorporate some updated landscaping? And there's also a situation with a residential parcel in the rear of the property.
Yeah, I don't believe...
Has there been anything on a consideration of having any type of covenant in a dedication to the town on that? Something to pull this whole process together to possibly make it look as I believe it was done on Sunny Road and Jericho Turnpike.
Well, in answer to your first question, I agree with you. It's dismal looking, and it's been that way for probably 40 years. And I certainly have spoken to my client about it, and I think that he would be amenable to putting landscaping in the front and beautifying it so that it doesn't look like someplace in Nassau County where they don't have enough room to have even a bush or a tree. As far as the rear goes and that line, I think that the residential portion is not used, for parking or anything, and I think that the retaining wall, I'm not positive of it, that's in the back, cuts across where the residential, it looks like...
It does.
It does. And I don't know. I don't think there's any necessity for the use of the property in the rear, but I would have to check with my client. Maybe that's a possibility.
Does that, I have a question on that, Frank. Does that piece of property in the back, does that butt up to that street that comes around? Do they have a frontage for that property on that street?
Let me just...
Abbott or not Abbott?
Looks like State Street.
Well, it was an extension of one street that goes down in a circle. You can see it there. I don't have the map with me, but...
The property goes back, but I believe there's, the development is short of that by at least 100 feet.
It looks like it looks like it fronts onto that street that comes around in a circle there.
Well, the property does, yes.
It does.
But
Okay.
the,
So that
it's
there's a way to
undeveloped.
develop that property under the present zoning there, but not come in there, not have any access there from Jericho Turnpike. It would come in there from a back street.
Right, and I'm not so sure there's access either. It looks like there is from the aerial photo, but I don't know.
Isn't it steep, isn't it? You mentioned it was...
Well, yes, but also, too, the back portion, and I apologize, you're supposed to have another copy of the zoning map. That the rear portion of the property is zoned residential.
It's what?
Is
It is
zoned
zoned
residential.
residential, yes.
And this is not the subject of the not the subject.
I know it's not
the
part of the application, but, rather than put a covenant onto that property or something there, does it back there onto a street there?
It does back onto a street, but the rear portion of the property is zoned residential. If I can.
Well, Frank, is that part of this particular section block and lot? Or is it a distinct separate parcel?
Here is very steep, I believe. Yeah, it is. I don't know if you can really get access there.
I think that it goes under the street here, right?
Yeah, but I think this back here is very steep.
Is it a
Came up
distinct
the last
parcel?
time.
Comes up on an angle.
Yeah, in other words, they came up the last time, we had the hearing on it. I asked about that, whether it could be accessed, and I think Frank said, and I think it's true, that this is a very steep slope going from here up to this street.
Do you want to add any comments?
I just have a question.
Let me see your map here for a minute.
It's actually two. The first one, it was noted in the memorandum that if the application's approved, one of the existing businesses will not fit within the NB district. And your client's aware of that, and they're
Yes.
still
Yes.
going, and,
The
you know,
car rental enterprise, yeah, yes.
and we could talk about the merits of WSI, but is it basically the basis of your application for your client is that in this particular location, forget about WSI as a whole, that's for another day or another place, the WSI is too restrictive in this particular location?
Absolutely.
Okay.
We're just trying to get an answer on that separate parcel. If it is a distinct separate parcel.
I think it is. I don't think it's part of the application. I think that came up at the hearing.
The entire site is one tax lot, but it's split zone between WSI, 200 feet from Jericho Turnpike. The rear portion is zoned residential R10. The application is only for the WSI portion of the
Right,
property.
That's correct.
The residential is going to stay residential.
Residential.
The application is to change the WSI portion of this lot to neighborhood business.
Right.
Well, my comments there on the application there are the same there as I've said before. When I came here in Smithtown in 1948, there was very little along Jericho Turnpike anyplace. And now that it's developed, and you have houses there with people there, 15 to 1,600 houses in an area that are not being serviced with any kind there of a neighborhood business type, I think that that's what needs to be addressed in this, in finding a way to fit their neighborhood business into the WSI until something is definitely changed. And it's not going to change my opinion on that, because that's what I've seen, is that people in $4 an hour, $4 a gallon gas there today, people are not going to ride, 2 or 3 miles there for something there. They're going to do second thoughts on it. So that's my feelings.
And is it possible to include in this resolution, if we do approve, the landscaping aspect?
Yes.
How do we articulate that specifically so they can comply with it? Somebody's got to put it in there.
Well, can we just have if we do go with the approval part of this resolution, maybe we could just go with a add-on saying subject to, or as we do it as a different letter saying that there be a landscaping update that is to be approved.
As provided
Or
by
to be
the Board of
considered-
Site Plan Review. That's
Fine, that would be right by site plan review.
That's good.
Yeah.
Yeah.
All right, thank
All
you.
right, everybody? Anybody else? All right. A motion there to recommend the approval of this petition to the town board for R&F management.
In the matter of R&F Management, LLC, number 2010-09, I move that we adopt the latter resolution as read by the planning department, recommending approval of the application, subject to the condition as stated concerning the upgrading of the landscaping on the property, subject to the review of the Board of Site Plan Review, or at the direction of the Board of Site Plan Review.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered.
Mr. Chairman, I'd
Thank
also
you.
just like to
We
make
thank you.
I'd also just like to make a motion to append the prior minutes of the CVS application dated June 3rd, 1998, June 17th, 1998, October 7th, 1998, as well as the associated memorandums to the record for the town board to consider this application, as provided to the planning board by the planning department on February 4th, 2011.
Did you make a motion, Mr.
Yes,
Austin?
I just moved.
I'll second that.
All those in favor?
Aye.
Aye.
Opposed? So ordered. All right.
Mr. Chairman, the next item on the agenda, under Part 5, Item 12, number 926, Countryside. The applicant requests to extend the performance bond for a period of 2 years to end on February 25th, 2013, in order to obtain more time to complete construction and all necessary improvements. The applicant received conditional final approval for this two-lot subdivision from the Planning Board on August 7th, 1996. A performance bond estimate in the amount of $9,086 was approved by the board and subsequently signed by the chairman. The applicant submitted the bond monies and all related materials to the town, and the town board accepted a passbook in lieu of a performance bond on February 25th, 1997. Planning board approval for this performance bond expired on February 25th, 2011. The engineering department contacted the applicant by letter dated January 20th, informing them the bond would expire and that they should contact the planning department to make the appropriate application to the board. The applicant submitted a performance bond extension application on January 28th to the planning department, and the application was distributed to all departments concerned for review. The traffic safety, engineering, and highway departments have no objection to the performance bond extension request and have determined that the bond amount is sufficient to cover all remaining improvements. The planning department has performed an on-site inspection of the subdivision and has determined that all of the public improvements appear to have been completed. Additionally, one home has been constructed on lot number 2, for which the building department issued a certificate of occupancy on December 22nd, 2005. The planning department has no objection to the applicant's request for an extension. However, we recommend that the applicant begin the performance bond release process at this time. At this point, the applicant can construct a home on lot number 1 as a building permit marker, and any public improvements that may be required at that time can be bonded by the engineering department. Therefore, the planning department recommends the performance bond be extended for a period of 6 months in order for the applicant to complete the performance bond release process. The planning department offers the following resolution for the board's consideration. Be it resolved, the planning board hereby approves a retroactive extension of the performance bond for the subdivision known as Countryside, number 926, for a period of 6 months to expire on August 25th, 2011. Mr. Chairman, this is the planning department's recommendation for Countryside, number 926.
Is there anyone here representing the applicant? Would you come to the mic and give your name and address, please?
Nick Neomonides, 173 Oakside Drive, Smithtown, New York. I'm here for the extension of the bond.
No problem there with the extension.
No problem.
Okay. Anyone in the audience that wishes to talk on this? A motion there for the extension of the performance bond on Countryside 926.
Mr. Chairman, I'd like to make a motion in regards to the performance bond extension Countryside number 926, that we approve the resolution as offered by the planning department.
Second? Is there a second?
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered. We thank you.
Thank you. Thank you.
Mr. Chairman, the next item on the agenda under Part 6, Other Matters. Item 13, number 1143, Gemini Landing. Mr. Chairman, this proposal was brought before the board by the applicant several meetings ago, and the board had requested an adjournment to receive a report from council regarding the viability of access to the property. Council did offer his report to the board regarding the applicant's request to use the Berry Hill access as opposed to Meadow Glen, and at this time, we'd like to know from the board, are you prepared to offer the applicant at a future meeting date decision as to whether you would endorse his desire to use the Berry Hill access or to use Meadow Glen?
You're asking us, do we want to give him a date as to when we're going to give a
No, no,
decision?
no.
He should proceed with his application with the Berry Hill, or should he change it?
Do we have a report from council for us?
At the last meeting, council made the report.
He has access through the easement, all right, and can utilize that to get onto Meadow Road. There's no reason to have a 200-foot driveway out onto Berry Hill.
So he has access through the
Yeah,
easement?
and it facilitates, particularly, that was what was the adjacent property owner?
The Dolans.
Dolan.
The Dolans have indicated they're going to proceed with their application as well, so it'll be a 50-foot ride easement into a right-of-way that both parties can access.
I believe we did a on-site also on this particular matter.
And I submitted the minutes.
You know, just as observing the situation, the Berry Hill would be sort of obtrusive to the current property owners on that particular cul-de-sac. So again, I think going by council's recommendations, it makes sense not only for the contiguous development of that particular parcels, but the understanding for the lifestyle and the of the current residents on Berry Hill.
Any comments from the board? Setting up, want to proceed there with a meeting there on their application?
You want to
He's
set up a
requesting
meeting?
their,
No, here's where we stand right
We
now.
want
The
to-
applicant, if you recall at the
That's
last
another way
meeting,
to go.
stated that he knew he could come out to Meadow Glen, but he prefers coming out to Berry Hill. And that was his statement at the last meeting. We had adjourned the matter originally because he said that his easement could not allow him to go out to Meadow Road, and that's why we asked him for a copy of his easement, and that's when we gave
We
it to
determined that he could go out
to
through
Meadow Road.
Correct.
Yes.
Right.
And then he acknowledged that when he was here, I believe.
Yes, but he also said he never stated, well, he said at the last meeting that he never stated that he couldn't come out to the Meadow Road. We believe that there was a misstatement there, that there was that. I would reiterate that both planning and engineering feel that the driveway should not come out to Berry Hill.
Berry Hill is the cul-de-sac.
That's correct. That we had deliberately shortened that cul-de-sac. If you look at the file map, the paper street shows a cul-de-sac coming up to the edge of the property. It was deliberately shortened because of the topographical changes, and we decided to go with a two cul-de-sac arrangements rather than have that hill disturbed that is there.
Well, if that went through, it would be basically, if I recall from going there, along the back of one resident's backyard and all across the front of the other guy's front yard.
Yes.
Right.
Okay.
no, it was not there a good. The easement, as long as he's got the easement to come in there off of Meadow Glen, then that's the way I think that he should do it.
Okay, well, what I will instruct the applicant is to either do one of two things, either modify the plan, or we will proceed on bringing the plan as he's proposed to this board, and you will make
Right.
your vote.
If he modifies it, then we'll vote on that, and if he doesn't want to modify it, then we'll vote on that.
Okay? And then we'll instruct him.
All right.
Okay? And that's all we need.
Mr. Chairman, there's one more item on the agenda. the adoption of minutes for the March 16th and April 6th, 2011 Planning Board meetings.
Adoption of the minutes for March 16th and April the 6th, 2011. A motion?
I move that we adopt the minutes of March 16, 2011, and April 6, 2011.
Second.
All those in favor?
Aye.
Opposed? So ordered. Anything else?
That's it.
Motion to adjourn.
Motion to adjourn.
Second.